Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. There has been some information that was placed on the public docket on December 31st, 2024. It is the reply to state's objection to defendant's motion to suppress and memorandum in support regarding the pen, trap, and trace device that provides us first time seen on the public docket some unredacted items as well as language, although this is a reply to the state's response in opposition to the motion to suppress this evidence. This is the evidence gathered by the pen, trap, and trace device that was provided to the Moscow Police Department to survey and to track Mr. Kohberger in December of 2022. There appears to be language here that goes to Mr. Kohberger's under seal motion for a Franks hearing. Now, as you recall, we've been covering on this channel for some time the fact that Mr. Kohberger filed his amended motion for a Franks hearing back on November 26th, 2024. It is all under seal, all of the evidence in support. What is Franks? Franks is a U.S. Supreme Court case from 1978 that states that a defendant may file a motion. He must or she must pass a 5-part conjunctive test. There's 5 elements to qualifying for this hearing, which is very rare. It is very difficult to obtain. But there is case law well established that if a party can prove by a substantial proffering of evidence that an affidavit for a search warrant contained intentionally misleading information, intentionally false information, or information that is recklessly provided without consideration of a person's constitutional rights, that it's possible to get that affidavit thrown out of the case. A very, very high standard to meet, because other case law tells us that when a magistrate or a judge issues a warrant, it is presumed to be correct. So there's a lot of barriers that someone needs to overcome to even qualify for a Franks hearing. Mr. Kohberger has several hearings scheduled to occur on the 23rd of January concerning his pending motions to suppress evidence, which is a much lower standard to qualify for such a hearing than a Franks motion is, and it seeks to suppress the evidence gathered, not to throw out the entire affidavit. And we see here, by looking at this very interesting filing, first he starts talking about the affidavit. The warrant was general. It wasn't specific enough to pass muster under the 4th Amendment to the United States Constitution and also the Idaho Constitution that prohibit illegal searches and seizures. But if we go to the bottom of page 4, you will see language that seems to suggest this is what he is also arguing in his under seal motion for a Franks hearing. There it is, ladies and gentlemen, the magic language under the second bullet point. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material evidence. And I will allow you to read what this says with specificity. I provided a link to this document where it appears. It's published on the Idaho Cases of Judicial Interest website. You go down to December 19th, 2024, and you can pull it up. The next page, they state here, this is Alyssa G. Massoff, who is signing this on behalf of the defense. Conclusion: Mr. Kohberger requests that this court suppress all evidence obtained by police via the warrant that permitted them to place a trace on Mr. Kohberger's cell phone number. CEL should be CELL, but we understand what it is. It's the 8458 phone that's addressed in the Affidavit of Probable Cause, signed by Detective Brett Payne on December 29th, 2022, that appears first item on the docket. It was used in support of the warrant for Mr. Kohberger's arrest. And prior to his arrest, apparently, what Moscow Police Department did is successfully obtain a surveillance on his phone, Mr. Kohberger's phone, to track him. And they're saying that's the evidence that should be thrown out. Now look at this, ladies and gentlemen. Unredacted information not seen before. This is the return of the search warrant that was signed by Detective Payne. This is Brett Payne on January 6th, 2023. Then we go into the Affidavit of Lawrence Mowry. This is on the next page. But this is not Lawrence Mowry signing this. This is Detective Brett Payne, Corporal Brett Payne. So it says here, Affidavit of Lawrence Mowry. Why does this not say Affidavit of Brett Payne? State of Idaho, County of Latah, I, Corporal Brett Payne, being duly sworn, do hereby state that the following information is true and correct to the best of my knowledge and belief. And he goes in and he states his credentials. Look at paragraph 2. Affidavit has been a trained and qualified peace officer for 4 years. He's not an affidavit, he's an affiant. That's a person who gives testimony under oath, which is what he's doing here. Affiant, not affidavit. Now he's saying here he obtained a search warrant on December 23rd, 2022. The warrant was served on December 23rd, 2023 by sending it to the FBI for service, as the FBI hosted the pen register and precision location response portion of this warrant. An inventory was prepared for all items received, and this information was placed into evidence at the Moscow Police Department. So that is what Detective Brett Payne is saying here under the Affidavit of Lawrence Mowry, where he's claiming to be an affidavit, but where he is an affiant. And then there's further information. Receipt and inventory of the warrant appears on the next page. That is unredacted. It was served upon the AT&T location. You can see there in North Palm Beach, Florida. And there's further information that's redacted for the first time. This unredacted, this is the order that was signed by Megan E. Marshall, the magistrate judge. And we see here that she is basing this order on information that was returned to her. It is supported by the prior information from the Moscow Police Department, and the order was then rendered. And there's further unredacted information, very explosive materials, very important materials. Now, just because the defense is saying these things, these are allegations, they're going to have to prove their case to Judge Hippler on January 23rd, 2025, at the hearings on the motions to suppress, of which this pen trap and trace device is one. But I believe here we have some clues as to what may be in that sealed motion for a Franks hearing. If you have any comments, any questions, any thoughts, please leave them here. As always, I thank you very much for your time and your attention.